Good morning, everyone. I'm Judge Jackie Powell, and we are in first appearance court. Today, I am going to be telling you whether I find probable cause to detain you and on the charges that have been presented, and then we will talk about release conditions. Today is not your trial date, so you may want to refrain from speaking on the record about anything pertaining to your case because everything in this courtroom is being recorded, and whatever you say today can be used against you at another time. In the courtroom, I do have the attorney from the state attorney's office, Mr. Eric Linder, and I also have an attorney from the public defender's office, Mr. Adam Goldberg.
Good morning, Judge.
And over at the main jail, who do we have?
Julie Chase.
And the main jail, we have attorney Julie Chase. Good morning, Ms.
Good
Chase.
morning. Good morning.
All right, and so in the courtroom, we also have confinement status and pretrial supervision services, as well as a representative from the clerk's office, so that everything will be recorded and we'll be able to keep track of everything that will be done here today. When I call your name, I'm going to ask you to step up to the podium, and I will address each person individually. I have already read all these probable cause affidavits that have been presented to me, but from time to time, your attorneys will make some arguments if it's necessary, and so I will hear from the attorneys as well. So we will start this morning with J. Charles Stewart.
Your Honor, if we could put this on a brief recall, Mr. Stewart is represented by private counsel who advised me he will be here shortly.
Okay, so Mr. Stewart will be on recall waiting for his attorney. Zachary Calvarese.
Yes, ma'am.
Do you have any children?
Mr. Calvarese, you're before the court this morning for count 1, touch or strike battery, count 2, possession of alprazolam, and count 3, possession of drug paraphernalia. I do find probable cause, and I'll hear from the parties as to bond.
Your Honor, I'm going to be requesting a $2,500 bond on count 1. Based on the level of violence that Mr. Calvarese punched his sister, kicked her in the face. He was arrested in 2015 for a domestic violence battery against his mother, and that charge was dropped.
All right.
Judge, at this point, Mr. Calvarese has lived in Broward County for 22 years. Currently, he does not have any source of income and no money in the bank. He was renting and staying in the apartment with his sister. However, after speaking with him, he can reside with his father. I believe that was in Lighthouse Point. He, at this point, cannot afford the $2,500. We were going to ask for 1,000 count 1 and ROR count 2.
All right, the court does find probable cause. I am going to impose a bond of $1,500 on count 1. The bond on count 2 is $1,000 and no victim contact until further order of the court. Thank you. John Hippolyte. Good morning, sir. You're before the court for 1 count of abuse child without great bodily harm. Count 2 is touch or strike domestic violence battery. Count 3 is driving while license suspended. Counts 4, 5, 6, and 7 are traffic capious matters. And then count 8 is an out-of-county hold. It's an out-of-county misdemeanor hold. That count 8 is a no bond hold, and it's not for magistrate. That hold is out of Hardy County. So I do find probable cause, and I'll hear from the parties as to bond.
Your Honor, on count 1, I'm going to be requesting a bond in the amount of $10,000. I have a concern that Mr. Hippolyte would allegedly strike an infant. On count 2, I'm requesting a $2,500 bond and no victim contact with both listed victims.
Okay?
Your Honor, he's been in South Florida for 23 years, currently employed as a server. At this point, he can live with his father, which would be separate and apart from the alleged victim in the case. At this point, he does not have any money accessible to him. It's my understanding that the alleged victim has the card that would give him access to any money or credit. I don't believe he has a significant history and would be relying on his father to bond him out. I would ask the court that bond, count 1 at 1,000 and count 2 at 1,000.
What kind of
And he
priors
can be placed on pretrial.
what kind of
Sorry?
priors does Mr. Hippolyte have?
Looks like it's mostly traffic with a misdemeanor drug prior. Basically, the issue with his criminal history is it appears he has issues going to court, noted by the capiases before the court and other failures to appear out of county.
Okay. Based on the allegations in this probable cause affidavit, the fact that there's a very minor child that's involved in this case, count 1, the bond is going to be $10,000. Count 2, it'll be $1,000. And then the other bonds in place will remain. No victim contact with either of the victims in this case. Ricky Bellevue. Ms. Bellevue, you are before the court today so that I can let you know that there is an out-of-state felony hold for you. It's a no bond hold. You should be going before the extradition court either tomorrow or next Tuesday. Extradition is Tuesday and Thursday, so one of those days you'll be before the judge. Brita Fox?
No problem, Your Honor. Good morning.
Good morning, Deputy.
All right, then.
All right, Ms. Fox is before the court for a misdemeanor capias. This is a municipal ordinance matter. This is, Mr. Shade would be the attorney on this case. I probably want to recall it if everything is okay over there at North Broward. I'd like to recall this case when Mr. Shade arrives. Is that okay?
Okay.
All
Yes,
right.
she's fine.
Okay,
That's
thank
fine.
you.
Come on. She's gonna recall you when you're trying to get to. Have a seat, right here.
Kara Bronson,
Present at the main judge.
thank you. Ms. Bronson, you're before the court for count 1, possession of drug paraphernalia. Count 2 is solicitation, and count 3 is a misdemeanor capias. I do find probable cause. What does Ms. Bronson wish to do?
Judge, is it possible to resolve these? The issue is that she didn't have a residence to receive her notice. She does not have the money to bond out.
Okay, State, do you have an offer for Ms. Bronson?
The offer be time served on 1 and 3.
Mental problems, never attempt suicide.
All right, if Ms. Bronson wishes to resolve her case, the charges today will be adjudication and time served on all counts.
Yes, Judge, thank you.
All right, Ms. Bronson, do you understand everything that's going on here today?
Yes.
All right, please raise your right hand. Do you swear or affirm to tell the truth?
Yes.
And you can put your hand down. Do you need more time to speak with your attorney?
No.
And are you under the influence of drugs or alcohol? You
No.
gotta say yes or no. Have you ever been treated for a mental or emotional illness?
Yes.
Are you taking any medications today that would prevent you making a decision today?
No. No.
All right. And you understand that you have the right to go to trial, but by taking a plea today, you're giving up that right.
Yes.
And do you understand that if you're not a U.S. citizen, by taking a plea, it could subject you to deportation or immigration changes?
Yes.
What plea do you wish to enter, Ms. Bronson?
No contest.
All right, I accept your no contest plea. Find that it's freely and voluntarily given. Your sentence is adjudication and time served. Good luck.
Thank you.
Samantha Asensio. Ms. Asensio, you're before the court for a misdemeanor KPS. It is on a criminal mischief charge. Looks like you failed to appear on February 12th to court. It's a municipal ordinance matter. So
Yeah, I was never aware of a court thing. I was never aware of this charge
this is
whatsoever.
Miss, today's Wednesday. It's Mr. McLawrence who handles. So I'll leave it for a little while for Mr. McLawrence to show up. Okay. Melinda Ventre. Ms. Ventre, you're before the court for two misdemeanor KPS matters. One's a municipal ordinance matter for an open container, and one is the state charges for possession of drug paraphernalia. Looks like you failed to appear to arraignment on March 13th of this year. And on February. So I do find probable cause. What does Ms. Venture wish to do?
Judge, she's not able to financially post bond on these cases, and the issue is not having a residence to get the notice of hearing. At this point, she's interested in asking the court if we can resolve this.
Okay, on the state, do you have an offer?
Offer on count 2 is time served.
All right, so on the possession charge, it's possession of drug paraphernalia. The offer is adjudication and time served. I will extend the same offer on the MO case.
Okay, Judge, she'd like to plead no contest.
All right, Ms. Venture, please raise your right hand. You swear or affirm to tell the truth?
Yes, ma'am.
All right, put your hand down. Do you understand everything that's going on here today?
Yes, Your Honor.
Do you need more time to speak with your attorney?
No.
Are you under the influence of drugs or alcohol?
No, ma'am.
And you understand you have a right to go to trial. By taking a plea today, you're giving up that right.
Yes, Your Honor.
Have you ever been treated for mental or emotional illness?
No, Your Honor.
And you understand that if you're not a U.S. citizen, by taking a plea, it could subject you to deportation or immigration changes.
Yes, Your Honor.
What plea do you wish to enter?
No contest.
All right, I accept your no contest plea. Find that it's freely and voluntarily given. And your sentence, ma'am, is adjudication and time served. Good luck.
Thank you.
Juliana Sadowski.
Judge, I do have a probable cause argument for
Okay.
Ms. Sadowski.
You can go ahead, Mr. Linder.
Judge, good
No,
morning.
I'm sorry, Mr. Goldberg.
That's quite all right, Judge. I'm going to object to probable cause on the DUI, which is count 1. The allegations are that the police officer observed her I don't want to paraphrase. Driving erratically by cutting in front of a vehicle without using a turn signal on at least 2 separate instances. And then the vehicle was, well, weaving within the left lane and also drifting over the lane markers on the roadway. That would, I think there was one other traffic infraction. That was it, following too close to the vehicle in front of her. Based on that, there was a traffic stop, and it took her a little bit to come to a stop. When the officer approached, he smelled the odor of alcohol and observed that her eyes were red and watery. The defendant allegedly advised that there was when asked about the odor of alcohol, she said that there was a testing at her work today, but that they only swished the alcohol and she did not consume it, which would explain the odor of alcohol and the red eyes. Judge, she refused to do any roadside. She refused to provide a breath. The only evidence that she is impaired is her driving pattern, which we all know there's plenty of drivers that conduct these sort of activities. I don't believe that there is sufficient evidence before the court that Ms. Sandowski was operating her vehicle under the influence of alcohol, where she is impaired. I agree that there is probable cause for count 2, the disobeying of the traffic device. She did make some traffic offenses, but I think taking as a whole, she provided an explanation, and there's not sufficient corroborating evidence to substantiate what the officer has written in his report, which is that she was operating under the influence beyond a level of impairment. So because of that, Judge, I would ask that there be no probable cause for count 1, the DUI, and I would ask that she be released on her own recognizance.
And Your Honor, just to mention in speaking to her, she does work at a hotel food and beverage company. That's the issue with the tasting, as counsel pointed out, and that the eye issue is that she was crying and upset at the time, less indicative of impairment.
Oh, that was the other point that I wanted to make, Judge, excuse me, that they asked her about her driving, and she said that she was on the phone with people discussing a staffing issue. Maybe that's what made her upset, that she's saying that she's crying, but she again explained her traffic behavior. It doesn't justify driving the way that she was driving. That's not the question. The question is whether or not there's sufficient evidence for the officer to have probable cause to arrest her for driving under the influence of alcohol while she's impaired. And I don't believe that there's sufficient evidence before the court today. And so again, I would ask the court to find no PC and to release her on her own recognizance.
Your Honor, frankly, everything I'm hearing are defenses to be made at trial, not for a probable cause for arrest. If Mr. Goldberg's explanation were acceptable, an officer could never make an arrest for battery as long as the defendant says, well, I acted in self-defense.
All right, thank you, everyone. I do find probable cause as to DUI and avoiding the traffic, which is not for magistrate. So let's talk about bond.
Ever attempt suicide? Ever attempt?
Judge, at this point, she has no prior history or prior arrests. I'm going to ask that she be ROR'd on this nonviolent offense.
Is that correct? There's no priors on Ms. Sadowski?
Well, Your Honor, yeah, do we have any information how long she's resided in the area? Because she only obtained a driver's license December 7th of last year. I show 0 months of residence. I'm not even getting into that.
Judge, she is not a flight risk. She did purchase a home locally where she has a mortgage on the home, but she does have a home that she owns. So it would be difficult for her to just drop everything and abandon these charges. She assured me that she will be present for court. She has no history of failure to appear.
Sir.
All right, I'll grant the ROR on count 1. Good luck, man.
Thank you, Judge.
Jacqueline Bass.
Judge, she was in North Broward. She still is in North Broward. I don't mean to say she was, but I spoke to her about the violation of parole, and after our conversation, I understand that she's absented herself from the courtroom.
All right, well, I do find probable cause, and she'll be before the parole board once that hearing is scheduled. Thank you, Deputy.
Thank you.
Natasha Walker.
Hi.
Judge, for Ms. Walker's case, I'm requesting a photo order.
I'll sign that. Ms. Walker is before the court for count 1, aggravated stalking after an injunction for protection.
And Judge, I'm gonna have a probable cause
And
objection
count
for her as
2
well.
is for aggravated assault with a deadly weapon without intent to kill. I'll hear from defense.
Okay. Judge, my objection is to count 2. I don't have an objection of probable causes to the aggravated stalking. I've received the petition, and the allegations are that Ms. Walker made contact with the alleged victim following the injunction. The objection that I have is to the aggravated assault with a deadly weapon, which is count 2. The allegations are that Ms. Walker went to the victim's home and broke a window, and she had in her hand a crowbar. I think they're presuming that she used the crowbar to break the window. And then there were other windows that were broken in the home. Clearly, that's criminal activity. I believe that there's probable cause for criminal mischief for breaking the window. But I don't believe that there's sufficient probable cause for aggravated assault with a deadly weapon. Just because she is inside the home when the windows are broken, I don't believe that that puts her in deadly fear that would rise to the level of aggravated assault. She's allegedly in the shower and glass breaks around her in the bathtub is the words that are used. Again, there's no allegation that Miss Walker was aware that the alleged victim was in the shower. There's no allegation that Miss Walker did this action directly towards the person of the victim. There's no allegation that the victim was in active fear that that touching was imminent. Again, I agree that there's probable cause for criminal mischief for breaking the window, but I don't believe that those actions rise to count 2, aggravated assault with a deadly weapon. So I would object to probable cause on count 2 as to aggravated assault with a deadly weapon. Again, I do feel that there is probable cause for another crime in count 2, but I don't believe aggravated assault deadly weapon is the appropriate crime. Thank you.
Your Honor, first off, I would note that Judge Siegel found probable cause for aggravated assault when he signed the arrest warrant. Secondly, I would note that the state has made a determination to file both charges as presented. Law enforcement has provided, as you can see, this arrest warrant was signed in December, so the state attorney's office has provided copies of the reports. I would also note, and I provided.
What happened? What happened?
What just happened? Who's attending to her?
Is Ms. Chase okay?
Is there somebody? Jesus.
Judge, can we go on recess, please?
North Broward?
Yes, Your Honor.
Deputy, do you have anyone there? We have a situation over at the main jail, so I'm trying to see if we can move some of the other facilities along. So if you tell me who you have.
Okay. Who? Frank. We have,
Brittany
Ms.
Prince?
Prince. Yes, ma'am, page 6.
All right.
Oh, wait, right? Polino?
I think we've done it. It's the one in the top.
Yes. Oh, that's it? Okay. All right. Ms. Prince, good morning. You're before the court today for one count of grand theft and count two is felony violation of probation. I do find probable cause as to the grand theft. The violation of probation is a no bond hold. So you will be before your division judge tomorrow at 8:30. And the bond on count one is $1,000, okay?
Thank you so much.
All right, good luck, ma'am.
Okay. Your Honor, we have Ms. Polino, page 7.
What's the last name?
Polino,
Okay,
Rachel.
Rachel Polino. Ms. Polino, you're before the court for one count of robbery with a firearm. I do find probable cause.
And, Your Honor, I need to provide the court with some explanation in this matter. Ms. Paulina's co-defendant is Richard Colon, who's later on the docket. I spoke with, he was arrested on an arrest warrant that was authored by Detective Sokol. I spoke with Detective Sokol this morning. You may recall we had Amanda Herrig yesterday afternoon. That was what I've been advised is that was a result of a misidentification. Ms. Paulino, as you can see in her PC, has made an admission to being the female involved in this case, getting the ride from the victim, directing him where to go, where her boyfriend then committed the robbery. I spoke about this first with Mr. Goldberg and then with Mr. Farberik, and I'm going to be requesting that the court sign an order RORing Ms. Herrig on the robbery firearm charge from yesterday. I'm going to be requesting that the court set the same $7,500 bond on Ms. Paulino that you had set on Ms. Herrig yesterday.
Okay.
No, it's the one we have
one
yesterday
yesterday.
afternoon.
That last name, Harry, you gave him the,
I'm going to give Mr. Farberik all the information.
okay. All right. So, Ms. Polino, you're before the court for a one count of robbery with a firearm. I do find probable cause. Ma'am, based on the allegations that's presented in this affidavit, I believe that a reasonable bond in this matter will be $7,500. And in an abundance of caution, no victim contact.
Thank you.
All right, ma'am. Good luck.
Okay. Your Honor, going down the line, page 13, I'm sorry, page 8, Donald Shanta. She's a medical reset today.
Yeah, she's been a medical reset for a few. Shanta Donald.
Yes.
Okay. Okay. All right. I'm not sure if Judge Cora, well, he signed the PC before, but what we'll do, Mr. Fabric is off the phone. I'll just find probable cause and. What page is Donald on again, so we can bring Mr. Fabric up to speed? All right, so, Mr. Fabric, I've been advised that on count two of the violation of probation, it was terminated by her division judge. So the only thing that's out there is a trespass. She's been a reset for a few days. So if you have no objection, I'll find probable cause, and then I guess if when she's ready to appear, we can talk about the bond or release or, okay. Right, right. Well, she went to court yesterday, so, or she went to court on the felony, so I don't know how there's a medical reset for the past 3 days on. Okay. All right. Okay, Deputy, who else do we have?
Then on page 13, Mr. Alan Scott, he's also a medical reset.
Okay.
I think he's already been, yeah.
All right, so
you're-
Alan Scott is a medical reset. Scott Allen, yeah?
yeah, and I can also, Your Honor, I'd ask the court to make a PC determination. I believe this is probably I think he was first reset on Monday.
Uh-huh.
I also know that I was CC'd on an email from the mental health specialist at the jail referring him to mental health court.
Okay. So he's already referred. I don't need to sign another order,
I mean,
or maybe I should sign one just in the
an
abundance of caution. All right, for Scott Allen, I'm gonna sign an order transferring him to, mental health, to Judge Lerner Wren. I find probable cause on this, and I'll sign that order. Okay, Deputy,
And as this is Bynum, on page 14, Ricky Bynum.
all right. And then, Mr. Bynum, you're before the court for one count of robbery, no firearm or weapon. I know this one. I do find probable cause. Those the parties wish to be heard as to bond.
Your Honor, just need to check something.
Judge, while he's looking, I can tell the court, it looks like Mr. Goldberg had spoke with him before. He's lived here all of his life. It looks like he was in between homes. His mom, it looks like, lives in Oakland Park. What I would be asking for, he's asked, it looks like he's asked Mr. Goldberg to ask for an ROR in this case, that he has no money.
Okay,
So that's what we would be requesting from the court at this time.
okay.
And, Your Honor, I'm going to be requesting a $10,000 bond, no victim contact. He was just released from Florida State Prison February 13th of last year. That was after he was convicted of robbery with a firearm or deadly weapon and aggravated battery with a deadly weapon. He was first placed on probation as a habitual violent offender. He then violated his probation, was sentenced to 30 months state prison. In 2008, he was convicted of robbery with a firearm or deadly weapon, sentenced to 5 years in Florida State Prison.
All right. All right, I'm gonna impose a bond of $5,000. And this, good luck, Mr. Bynum.
So is it going home today?
No, sir, your bond is $5,000 unless you post the bond.
I ain't got no money to post no bond, ma'am. I didn't do it. When the police
Sir,
came
don't talk
on
about the
me-
facts of
Don't
the case,
talk
okay?
about your case, talk to your attorneys, and then you can just make a determination what to do.
Okay, page 16, Bozeman David.
Okay. All right, David Bozeman. Mr. Bozeman, you're before the court for one count of burglary on occupied dwelling. I do find probable cause. Do we have mental health issues? Do we know?
I suspect so.
Mr. Faberg, you have notes from, on Mr. Bozeman?
I do, Judge. It indicates that he's lived here for approximately 8 months, that he's currently homeless, he's not working, has no family members here. He would be unable to post any bond at this time. We would be asking that he be ROR'd, or in the alternative, that he be placed on standard pretrial release.
And, Your Honor, I'm showing that he has an open criminal mischief, resisting without violence in front of Judge Diaz. He has resolved a trespass in early March of this year before Judge Diaz. He was just arrested 10 days ago on a trespass. He resolved a grand theft from this year on February 18th. Excuse me.
All right, the allegations here that Mr. Bozeman is found in someone's home taking a shower, and there is concerns for the community based on that, and I am going to impose a bond of $2,500. If there's any other evaluations that need to be done, I guess, at the felony level, that should be handled. No victim contact, sir, no return to that location. All right.
Yeah. Your Honor, that's it for us, except for Ms. Fox, who is an MOK.
Ms. Fox, oh, that was the lady that we called earlier?
Yes.
All right. All right, we can.
You want her back?
Yes, bring up Ms. Fox, please. I don't believe, State, I know this is a municipal ordinance, but can you let me know if Ms. Fox has any priors?
Certainly.
Ms. Fox, good morning.
Good morning.
Ma'am, where do you live?
At homeless shelter.
Okay. How long have you lived at the shelter?
Probably under a year on and off.
Okay. So, do you know that this location that, that they said you were, where you were not supposed to be,
Yes.
you can't go back to that location, do you understand?
Yes, ma'am.
You've got to stay at the shelter, wherever else, whatever else you do during
Yeah.
the daytime, do you understand that?
Yes, I do. There are very few places to stay legally.
Yes.
That's a problem.
So then you've got to stay at the place where you are allowed to stay,
Okay.
okay?
Yes, ma'am.
I don't see any history, Judge.
Yeah.
Ms. Fox should be aware, if she doesn't already know this, she has another open trespass at South Satellite, and she's scheduled for arraignment on April 11th before Judge Cathon at 1:30 in the afternoon.
Did you hear that, Ms. Fox?
Yes.
You have another case that, that is pending for arraignment that you're gonna have to attend.
Okay.
Do you have a way of, from the shelter to get a ride to court?
No, I don't. I don't even have a way to get to the shelter from here.
Well, then, well, then you're gonna need to talk to them. On this case, Ms. Fox, I'm gonna sentence you to adjudication and time served, okay?
Thank you.
All right, good luck, ma'am.
Thank you, ma'am.
All right. Sure.
Jay Stewart.
Jason.
Sitting right in the front there with the beard. It's a domestic.
All right. All right, Jay Stewart.
Steve Melnick on behalf of Mr. Stewart.
All right, Mr. Stewart is before the court for count 1, aggravated battery causing bodily harm, and count 2 is false imprisonment, child under 13 years of age.
Your Honor, we would ask that there be no PC on the false imprisonment child under 13. I've read the PC.
Your Honor, the PC charges of false imprisonment. The child under 13 is what BSO put on the booking.
Right. I do find probable cause just for the false imprisonment. I don't know why it's child under 13.
Neither do I.
So it's aggravated battery and false imprisonment.
We'd ask 5,000 each count, Your Honor.
All right, State?
Your Honor, I'm going to be requesting 10,000 on one, 5,000 on two. I would note, one moment, Judge. Okay. He was arrested last year for felony battery due to priors against the same alleged victim that was dropped. In 2012, he was arrested for a battery that was dropped. In 2009, he was convicted of battery on a law enforcement officer, misdemeanor battery. He violated probation, sentenced to 15 months in state prison. 2004, battery on a law enforcement officer resisting with violence, violation of probation, 15 months state prison.
Your Honor, this victim, the case last year, she came and admitted she lied, and she has a severe substance abuse problem, and when she's on a bender, she goes and gets him arrested. We're gonna present everything to case filing, and Miss Mercier is going through a dependency case where she's about to lose her child to Mr. Stewart and her sister. This has been an ongoing, she has major issues. We would just ask that you set a reasonable bond, even $5,000 total, and he will stay away from her. And that's all we're asking.
So there's a pending dependency matter?
Against her, correct.
Okay. All right. The court does find probable cause. I will impose a bond of 5,000 on each count. No victim contact until further order of the court or whatever order comes out of the
That's
dependency
fine.
court.
Thank you very much, Your Honor. And I'll let Mr. Stewart know I'll call Brad for him. Okay, Jay? Okay, nod your head. Okay, thank you, Your Honor.
You're welcome.
Okay, bye.
All right. Can we then? We do Natasha Walker? I had it to the side. I don't know if it's the one that we had before. There was Natasha Walker? That's the one that we were on? Okay. Okay. All right, do we have Natasha Walker? All right. We were in the middle of this one before we had to go to recess, so I'll just start from the top. That Ms. Walker is charged with aggravated stalking after injunction, and count 2 is aggravated assault with a deadly weapon. Mr. Goldberg was in the middle of making an argument about whether or not the victim had present sense of Ms. Walker being outside with a crowbar as to be in fear. I don't know if we got to that place, but I do find probable cause despite his argument.
And, Your Honor, I can't advise the court. I'm looking, as an officer of the court, I am reviewing the victim's sworn statement, and she did, the broken window was a bathroom window. She went to the window and saw Ms. Walker running from her home with the crowbar and identified her.
Okay. All right, so let's talk about bond.
Your Honor, I'm gonna be asking for a total bond of $50,000, so I would ask 25 on each count. No victim contact, pretrial release with a GPS monitor. I provided both the court and defense counsel with a copy of the victim's petition.
You gotta wait, ma'am.
As you can see, the petitioner/victim is trying to go within the law to keep her and her children safe. There's allegations leading up to it that Ms. Walker repeatedly refuses to stay away from this person, to leave her alone. Now she's been court-ordered to stay away from the person, and now she's continuing the same behavior, damaging her property, smashing out windows in her home where her children live. This woman is in fear of Miss Walker. She's in fear for her well-being, for her children's well-being, and this woman is is trying to rely upon the system to keep her safe. So I believe these bonds and a GPS are necessary to act as deterrents to ensure that Ms. Walker will now follow the injunction order and what I imagine will be this court's order to stay away from this person.
All right, good morning. Ma'am,
morning.
you're not here when we started court earlier. So what I want to let you know is that I don't know what you know, but do not talk about the case. I only want to hear now about setting a bond.
I don't have no money. Natasha worked, and she really don't have no money.
Okay?
And I know right now she may lose her job. I don't know, so.
Well, there are several things that the court takes into consideration in determining release conditions. And so, sure, one of them is the amount of money that you have, but then there's also, there are other things that I have to take into consideration, concern for the safety of the community, priors, all that. And here before the court today, there's an injunction that tells Ms. Walker to stay away from this person, and the allegations here, this is not trial, so certainly she'll have her day in court, but the allegations here is that Ms. Walker went to the same place where she's told not to be and caused damage, okay? And so this morning, I do find probable cause, and I am going to impose a bond of $10,000 on each count, so it's a total of $20,000, along with a GPS monitor. She has an order from another judge to stay away, and that hasn't kept her away, so I have to take all of that into consideration, okay? All right,
What
good.
is $20,000 the money? I don't have money, but how much is that?
Talk to your attorney, and they'll talk to the attorney, and they'll give you some more information, okay? Yes. All right. Kania Jones. Mr. Jones, you're before the court for one count of,
That's definitely not Ms. Jones.
no, it's Miss Kania Jones. Yes.
Can you finish the case number? I think it stopped at 1985.
It didn't even start. So what is the case number?
1701985.
Wait, 170.
1701985.
All right, Ms. Jones, you're before the court for one count of felony violation of probation. It is a no bond hold. I don't know when you'll be going to court, but you should be going before your division judge shortly, okay? Sierra Jackson. Ms. Jackson, you're before the court for one count of grand theft auto, and count 2 is using a forged credit card. I do find probable cause as to both counts, and I'll hear from the parties as to bond. Oh, on this one, before we go, the allegations are that she attempted to get the car. She used a credit card and when it failed, so she didn't get the car.
Well, yeah, I mean, under the theft statutes, I would argue she endeavored to obtain the vehicle, which would still.
That's why I wrote that. Okay, I got it. All right. Good to see you. Yeah. Well, Ms. Jackson, we'll recall you in a little bit, once we get some more information. Just hold on, let me call, William Hennigan. This is Mr. Shade is here. Mr. Shade, I wasn't sure that you were coming back. Ms. Fox, I handled.
That's okay, no problem.
Okay.
Judge, on page 9, Mr. Hannigan.
William Hennigan? Mr. Hennigan, you're before the court for 3 misdemeanor capious matters, open container, and sleeping on property.
Judge, I can tell you the city of Hollywood thinks he's on the cusp of receiving some extra time, but I'd be asking for time served on these.
He's on the cusp.
Cusp, he's getting close to them asking for more time. So, Mr. Hannigan, do you understand that if you get arrested again, it's not gonna be time served off, or it's gonna be a longer jail term? Can you hit that button? Hit the center button so we can hear you. There you go.
All right, Mr. Hennigan, the sentence is going to be adjudication and time served. And you need to try and find a shelter or somewhere to go so that you don't get caught up in this anymore, okay? I think he turned it off.
It's okay.
All right. All right, good luck, sir.
Thank you, Judge.
All right.
Is she okay? Was she okay?
I haven't, no word. They're not giving us any word. Thanks. All right, Mr. Faberg, did you have notes on Miss Jackson, Sierra Jackson?
Sheila.
Okay. Okay.
Judge, I can tell the court on Ms. Jackson, Ms. Chase's notes indicated that she is a hairstylist, that she has 2 children that she supports, that she lives with her mom currently, so she does have family members that live here in the area, and that she indicated she has no prior. She would be asking the court to be ROR'd or in the alternative to be released to pretrial standard.
Okay.
And Your Honor, I wouldn't have an objection to pretrial considering she's currently in a diversion program and date on a theft.
All right, I'll release Ms. Jackson to pretrial supervision. Ma'am, they'll give you the address and the directions to the pretrial services. You must report there within 24 hours of your release. Failure to do so will lead to your arrest, okay? All right, good luck. Will somebody please give Ms. Jackson the pretrial? Ms. Jackson? I need Ms. Jackson to come back to the podium, please. Okay, I just wanted to make sure that you had that information. Okay, good luck, ma'am. All right. Marie Benoit. All right, ma'am, you're before the court for 1 count of battery on an officer, count 2 is resisting officer with violence, and count 3 is trespassing occupied structure or conveyance. I do find probable cause. Yeah. And I'll hear, ma'am, good morning.
Good morning.
Are you related to?
Yes, I'm
Ms.
Lisa, Mary mom.
Okay, good morning. Do you wish to say anything in regards to setting her bond?
Yes, I know she gave months, 2 months ago, she gave birth to her baby.
Okay,
And then I know she going through a lot, stress, a lot is going on with
okay.
her. But no matter what, love still loves. But the boyfriend don't have enough time for her.
Okay, don't talk about that. We just want to talk about the bond, because you may have to tell her attorney that at some other time, okay? Today's not that hearing. We just want to hear about how much bond can you afford? How can you help her? I heard that she's got a new baby, all right? And so then, if you're gonna post a bond, how much are you able to afford?
Judge, if I could just kind of break in, I can tell the court that she's lived here since 2009, so she's been here almost 10 years.
Okay.
She does live with her parents.
Okay.
As the court can see, she has a 2-month-old baby that, apparently she's been struggling. It sounds to me as if perhaps postpartum. There's some other issues that are going on, of course, with the boyfriend and that. But she has no prior record. I would ask the court, in light of the fact that she lives with her parents, she's been here for 10 years, has ties to the community, I would ask the court to consider RORing her.
Mr. Linder, you wish to be heard?
No, Judge.
All right, so I'll grant the ROR on these counts. She has to, I guess she has both of you to help her, so she has to pay attention to the mail to see if she has to come back to court, when she has to come back to court, okay?
Your Honor, the only
And,
thing I would request is that there be an order no return to 4126 Inverary Boulevard.
Okay. So this incident, or this location where the boyfriend lives, no return, and no contact with him as well, no victim contact, okay?
Thank you, Judge.
That means, Ms. Benoit, no phone calls, no asking your parents to make a phone call for you, no text or email, no contact means no contact. Do you understand that? Okay, all right.
Thank you so much.
You're welcome. You need him? Oh, Mr. Fabric, I think they have some info that you can. Mr. McLawrence, we can address Ms. Samantha Asensio.
Good morning, Judge.
Good morning. Ms. Asensio, you're before the court for a misdemeanor capias matter on a criminal mischief charge. I do find probable cause, what,
Judge, in speaking with the city prosecutor on this matter, it appears that there is a restitution amount that's owed.
oh,
So, I did notice that the court, notice of Ms. Asensio's court date was mailed, and it was returned to the clerk's office. And the address that I noticed on her original notice to appear is a 7855 address in Miami, Florida. She indicated to me that she didn't live at that address, and she no longer lives at that address, and she did provide me with an address here in Fort Lauderdale. So on the basis of that, Judge, she indicated to me that she has no priors, and if that's true, and her absence was not willful, it was not intentional, I was going to request if the court would ROR her on this criminal mischief, give her an opportunity to pay that $100 restitution, and in the hopes that the city will then decline to go forward with prosecution. She does have my business card. I told her it's no one's responsibility to make sure she does what she said she was going to do. So she'll have to go ahead and follow up on that. So I'm requesting that the court would ROR her and give her the opportunity to do so.
all right. Ms. Asensio, it is your responsibility to make sure that the clerk has the correct address for you. So you need to make sure that you go and get that taken care of, so that that's not going to be a reason for you not to show up in court again, okay? I will grant the ROR at this time, and good luck.
Ms. Asensio, you have my information. Again, I'm not going to follow up with you. You need to follow up with me. You understand? Okay, thank you.
All right, Mr. Yes, yes. Thank you. Mr. Favera, can you let me know, or when, or, I know everything is kind of. All right, so do you want me to continue calling, or are you waiting for?
Yeah, you can. What I'm doing is, Mr. Sanders is on his way.
Okay.
Get there, but in the meantime, I can call and get her notes.
Okay, William Green? That's the person?
I think,
Okay,
yeah,
I can't hear you.
I read enough of that.
What's going on? Now we have no sound.
There we go.
I can hear when it clicks, but try again. Nope. You're gonna have to start sending out smoke signals. Oh, he's the one involved in this incident? All right. Okay. All right, we have to try and fix the microphone. Nope.
Your Honor?
Yes, now I can hear.
Conti only had one guy. If you can call that a turn.
Oh, I got excited. I thought I was at Brevard. Okay, who do we have at Conti?
Michael Taylor. He's the last person.
Okay,
Change the charge.
All right, Mr. Taylor, you're before the court today. It's a change of charge. The charge was previously presented as burglary on occupied conveyance unarmed, and now it's changed to attempted burglary.
Yes, and Your Honor, you found PC for attempted burglary at the first appearance
Okay,
and set the bond at 2,500, so I'd ask that Your Honor place that bond back on him today.
so what happened why we're back again? If we-
Because it was booked
Because it wasn't on the,
as a burglary, they couldn't book it as attempt.
it's a, yeah, but I'm thinking if we found probable cause for attempt, I must have written it on the PC.
You did, but in the system, the charge in the system doesn't get changed until we file a change of charge,
How much was the bond?
2,500.
Thank you.
But I agree with you.
All right, Mr. Taylor, you're brought back just for us to let you know that the charge has been changed, as I said before, from burglary unoccupied to attempted burglary, which is what we found at a magistrate in the first place. So the bond remains at $2,500, okay? All right, good luck, sir.
Your Honor,
Yes,
he's also scheduled for PM court, magistrate.
for what?
That's what I'm asking.
Does anybody know what Mr. Taylor is scheduled for?
I'll check. See.
There's another burglary? And we don't have that paperwork? All right, sorry, deputies, there's another charge that's
Okay, no
coming,
problem.
so we'll see him later.
Yes, ma'am.
All right.
Thank you.
Okay. All right. Have we made any progress with the microphone over at the main jail? Uh, all right. So main jail confirmed that the microphone's not working. And then let me know what number we have to call.
Okay, they're on the line trying to get it fixed.
Okay. No, that's fine, it's been that kind of morning.
He's on the line with the guy from Texas.
All right.
I know they replaced it over, I think Monday they had a new microphone there.
All right, is the mics working? Nope. Oh,
They were working on it apparently, but the guy hasn't gotten it.
okay.
You can call the public defender, she sits just to the left of the screen, she can put it on speaker, the number's 954.
Do I have to dial all the?
Magistrate Court.
Hi, this is Judge Jackie Powell. So the speaker is not working, so we're gonna try and work through the phone on speaker. Okay?
Okay, Your Honor.
All right, who do we have over there? Mr. Sanders is over there? Okay. All right, so next we'll go to Amaya Cruz. So, Mr. Cruz, you're before the court for one count of failing to register motor vehicle, and count two is operating without a valid driver's license. Counts 3 through 7 are misdemeanor capious matters, and those all have bonds attached to them. You will be before your division judge tomorrow at 8:30. So I will leave the bonds in place, and tomorrow you'll go before your division judge to see if you can resolve or however you'll move forward on all these cases, okay? All right, good luck, sir. James Mack. Mr. Mack, you're before the court for a misdemeanor capious matter on a possession of cannabis charge. I do find probable cause. This was,
No objection to it.
okay. All right, this is a capious from December of 2018, and your bond is $1,000, sir. Okay? All right, good luck. William Jones. Mr. Jones, you're before the court for one count of petty theft. The court, I do find probable cause. What does Mr. Jones wish to do?
He's saying that he can self-bond, Judge.
All right, so your bond is $25, sir. Good luck. Dennis Barry.
Your Honor, he's disabled and on disability. He's lived here all of his life, and he's seeking pretrial release.
Okay. All right, so Mr. Barry, you're before the court for count 1, touch or strike battery. Count 2 is a criminal mischief, and count 3 is resisting without violence.
Your Honor, I was actually going to be requesting a bond increase. I am concerned, one, just based on these allegations, the level of violence against this person as characterized just completely out of nowhere. I'm also showing, one moment.
And Your Honor, he would accept some kind of house arrest, Elmo, GPS.
Well, my concern is this happened at his home, so, but also noting he's out right now on 2 counts of battery before Judge Diaz.
Okay. My concern is that based on the allegations is that he's really sleeping, his sister is allowing him to sleep on the back patio. Where is he going to stay? She's the, is she- And with two pending batteries, and then this is a third one. I'm gonna leave the bond at $1,000. If there's, some arrangements that can be made for him to go to another place, then I'll consider that at a later date.
And, no victim contact?
No victim contact and no return, no victim contact and no return to that location. Mr. Barry seems to be saying something. What is he saying? Mr. Sanders? What is it again?
Hello, Your Honor.
All right, it looks like Mr. Barry was saying something, so I was asking, what is it that he's saying? Or is it something that you want him to say?
Saying he can't afford any kind of bond, and he has a bedroom that he can live in.
All right. Well, I'm gonna leave the bond at $1,000 at this time. Good luck, sir. Irvin Murillo Domingo.
Bond adjusted.
Thank you. Brian Sears. Mr. Sears, you're before the court for one count of touch or strike battery. I do find probable cause. Does the parties wish to be heard as to bond?
Your Honor, based on the nature of the battery, I'm requesting a $2,500 bond.
We're just asking if the bond stay
All right, Mr. Sears, your bond is $1,000, no victim contact until further order of the court. John Monahan. Mr. Monahan, you're before the court today for count one, a DUI, alcohol or drugs, and count two's DUI with a balance, a breath of greater than .15.
Your Honor, we would just ask that count one is subsumed into count two, and so we ask that you take the bond off count one.
Your Honor, I would disagree. This is not, count one is not just a straight DUI. It's because it's a second offense, which is a cause for concern. Considering it's a second offense with enhanced breath, I believe a $2,000 bond is appropriate.
All right, I do find probable cause, Mr. Monahan. You have a bond of $1,000 on each count. Good luck, sir. Trayvon Sutton.
Judge, we have no objection to 1,000 in light of the other holds.
Okay, so Mr. Sutton, you're before the court for a grand theft auto. I do find probable cause. Your bond, sir, is $1,000. Good luck. Jerry Joseph. Mr. Joseph, you're before the court for one count of driving while license suspended. Count two's burglary, unoccupied dwelling unarmed. Count three is grand theft. Count four is dealing in stolen property via internet. No. I do find probable cause as to all those counts. And I will hear as to bond.
The judge, he's seeking a $2,000 bond. He says he can make $5,000 in the aggregate. He lived here for 33 years, so he's not a flight risk. He has 4 kids as well. and he works as a landscaper full-time.
Okay.
And, one moment, Your Honor. Your Honor, I'd be requesting a $10,000 bond on count 2. This is someone's home. Total loss from the burglary appears to be between $4,000 and $6,000.
And does Mr. Joseph have priors?
One moment. Michelle, do you have anything? He's not up. It's not the same person. It's not the same person. Yeah, that's count 1.
All right, I'm, at count 1, the bond is $750. On count 2, I'm gonna impose a bond of $5,000. Count 3, 1,000. Count 4, 1,000. And no return to this location, sir. Good luck. All right, next we have Terrence Felder.
I believe.
Okay.
He was removed by the docket by confinement.
All right. Is that, okay. Zachary Hall. Mr. Hall, you're before the court for 1 count of grand theft. Count 2 is a petty theft.
Judge, we're seeking pretrial release. He can't make a monetary bond. He's 4 years lived here. He can live with his fiance and has a 7-month-old child to support, but currently is looking for work. I don't believe he has many as way as priors.
Okay. Oh. All right, there's 2 affidavits there. Okay, so, say,
Your Honor, my only concern is I've got an at-large address in Deerfield Beach on one report and a Boca address on the other report. If Mr. Sanders or if Your Honor inquires and there's a little more information about where in fact he's gonna be staying, I know we were advised the fiance, and I wouldn't have a problem with pretrial.
all right.
He's saying he can live with his fiance and mother-in-law. Do you have an address?
Yeah, how long?
Not so fast. 11636 Venetian Avenue in Boca Raton. 33428.
Is that a house or an apartment?
House, Judge.
Okay. All right, I'll release Mr. Hall to standard pretrial supervision. Sir, they'll give you the information, and you need to report within 24 hours. Failure to do so will lead to your arrest. All right, Jacob Fott. Do we have Mr. Fott? Is that him sleeping?
He's
coming, Judge.
Okay. Mr. Fott, you're before the court today for count 1, premeditated murder, and count 2 is felony violation of probation. The felony violation of probation is out of Palm Beach County, where you have a no bond hold. I do find probable cause, and I'll hear from the parties.
Your Honor, I'm going to be seeking a no bond hold upon a finding of proof evident or presumption great for first appearance purposes only. Oh, he told me you guys did. Adam told me you had it. relying upon the affidavit from Detectives Samantha Cottom, the Broward Sheriff's Office, relying upon not only DNA evidence that was collected from the scene, identifying Mr. Fott, but also, Your Honor, relying upon an identification of surveillance stills and video. At the scene, identification was made by his stepfather, who also advised that Mr. Fott confessed to the murder that evening.
And Judge, we would just object to proof evident presumption great based on an affidavit that doesn't have personal knowledge. If they would have presented somebody that maybe an affidavit that of someone identifying him, or an affidavit of maybe even his statement, but they've presented nothing than a summation by a police officer who has no idea of what personally happened. So his affirmation is a nullity.
That argument, Your Honor, that would require for any punishable by life offense or capital offense for a court to find proof evident presumption great, the detective or officer would have actually had to have been present when the offense occurred, which I don't believe is the standard.
All right, the case law does allow for the court to make a finding of proof evident presumption great based on the affidavit and the information that's presented therein. Based on that, I am going to make a further finding of a preliminary finding of proof evident presumption great. And Mr. Fott, you will be held no bond well, it's no bond on count one. You'll also be held no bond on count. It's no bond on count one for the violation of probation. You'll also be held no bond on the premeditated murder charge. Good luck, sir.
Sorry.
Is the microphone fixed? Okay. All right, Sergio Gonzalez.
I'm here.
All right, I kind of heard Mr. Gonzalez, though.
You still have the felony paperwork, or was it picked up?
Is that through the phone? All right, Mr. Gonzalez, you're before the court for count one, possession of methamphetamine, and count two, possession of drug paraphernalia. I do find probable cause. Do we wish to be heard in regard to Mr. Gonzalez?
I don't know what page we're on. 16.
16.
Oh, it's Orpesa Gonzalez?
Yes.
He's asking for ROR, Judge. He says he can't make a monetary bond.
Okay, state.
One moment.
He's been here 24 years, which looks about his age. Is he?
Yeah, he is no, well, one moment. He has an open felony out of Dade County.
All right.
He doesn't know about that, so it may be someone else.
Mr. Verberg, do you want to come over here? I don't.
Okay.
And Your Honor, I just showed in Florida's CCIS system. I showed Mr. Fairbear the information I'm referring to. He could see the type of offense and the reason why I don't necessarily want to go into specificity about that.
All right, thank you. I am going to leave the bond at $1,000. Good luck, Mr. Oris Pesa Gonzalez. Yes. Yes. No. No. All right. Richard Januskiewicz. Sir, you're before the court for count 1, retail theft, coordinating with others, count 2, grand theft, count 3, resisting officer without violence, count 4 and 5, also grand theft.
Your Honor, he says he can't make a monetary bond. He's asking for pretrial release. He has a drug program slated called Incentives that his father's going to pay for the entry fee in Boca Raton.
Okay.
Showing he's got a warrant out of. It appears he's got a bench warrant out of the District of Columbia on a no bond for a violation of probation for a theft-related matter. That warrant's from 2015. He's also got a warrant out of the state of Maryland from 2015 for a probation violation on a forced entry burglary of a residence. Out of Broward, he had a grand theft in 2015, violated his probation, was sentenced to 364 days county jail.
And Your Honor, he would take some kind of GPS, level 2, possibly just custody to the program.
Honor, 2015 Palm Beach County shoplifting. I see he's been arrested down here on out-of-state warrants.
All right, I'm denying the request for a pretrial. The bonds will remain in place. George Bullard. Mr. Bullard, you're before the court today for 1 count of possession of cocaine. I do find probable cause. What does Mr. Bullard wish to do?
Keep the bonds in place. He has a program with Judge Merrigan.
He's in front of Judge Merrigan. All right, Mr. Bullard, your bond is $1,000. Damon Nicholas. Mr. Nicholas, you're before the court. Count 1 is grand theft. Count 2 is possession of cannabis 20 grams or less. Count 3 is resisting officer without violence.
Your Honor, he's saying he can't make a monetary bond. He's asking for standard pretrial release.
So March 21st, he's posted a bond? Yes. And, okay.
And that would be,
He's saying that was $25.
Okay.
no, it was $500 on a felony criminal mischief. The $25 was, I don't know what that was, but he was also arrested March 10th on a capias on a trespass that he pled out. Yeah, the $25, that was on a trespass arrest from mid-February.
I'm gonna deny the pretrial. The bond is $1,000. Good luck, sir. Kelly Figaro.
Medical rehab, Judge.
Thank you. Kevin Davis. Mr. Davis, you're before the court for one count of grand theft.
Your Honor, he's asking for standard pretrial release. He can't make a monetary bond.
All right, state.
Shouldn't, but I have no objection to pretrial, Your Honor.
Great, so Mr. Davis, you'll be released to standard pretrial supervision. Good luck, sir. Richard Cologne.
Guarantee it.
Do we have Richard Cologne?
I'll check to see.
Cologne's there. He's
Somebody's sleeping, so I don't know.
Yeah, that's him.
All right. Mr. Cologne, you're before the court for count 1, robbery with a firearm. Count 2 is illegal use of credit card to obtain goods over $300. Count 4 and 5 are misdemeanor capias, and counts 3 and 4 misdemeanor capias. Count 5 is a traffic capias.
And, Your Honor, on the robbery firearm, I am going to be seeking a no bond hold upon a finding of proof evident or presumption great. I would note Mr. Cologne was caught on surveillance video at a Wawa gas station using the victim's credit card the day after the robbery. He was identified by someone that advises he has known Mr. Cologne for approximately 15 years. I would also I'm relying upon the arrest warrant affidavit, but Your Honor, I would also be relying upon the probable cause affidavit prepared by Detective Sokol for his co-defendant, Rachel Polino, who incriminates herself, placing herself at the scene, and also identifies Mr. Cologne as the person that committed the armed robbery and is her boyfriend.
Ms. Polino was before the court earlier today.
Your Honor, my argument that I had before, I'm asking that you not find proof evident presumption great. They presented a probable cause affidavit that doesn't have personal knowledge. I understand that they can rely on affidavits pursuant to ISAZA, but ISAZA cites to Preston versus Gee. And in Preston, they lampoon the probable cause affidavit alone, falling well short, and talk about how it's circular for someone that doesn't have personal knowledge to be defiant to things and is of little help to the court. That's on page 1227 of Preston versus Gee. And ultimately, they found the probable cause affidavit was not sufficient. Now, that's not in conflict because ISAZA itself cites to Preston versus Gee.
And Your Honor, my reading of Preston is not that the Second Circuit found that a probable cause affidavit cannot satisfy proof evident or presumption great. The finding was the probable cause affidavit in that case did not contain evidence that rose to the level of proof evident or presumption great.
All right, thank you, counselors. I do find probable cause. I am going to make a preliminary finding of proof evident presumption great. And Mr. Colon will be held no bond.
And Your Honor, I'd be requesting a $1,000 bond on two.
Hold on just a moment, Mr. Linder.
I'd request a $1,000 bond on count 2.
Okay. I will go, Mr. Sanders, you were saying?
Yes, Your Honor. I was asking if you could use discretion to set bond at $25,000. he's a 20-year resident of South Florida. He has a adult daughter and grandchildren, and he's not a flight risk. He can live at his mother's, and you can ameliorate the concern of safety of the community with some kind of GPS Elmo monitoring.
And Your Honor, I would just advise the court, in addition to the capiases and for failures to appear in court that he has right now, Mr. Colon, under the name Richard Colon Rodriguez, has a pending aggravated assault, a deadly weapon, and battery before Judge Allspector.
It will remain no bond on count one. Good luck.
And is the court setting the bond at 1,000 on 2?
Yes, and 1,000 on 2.
Thank you.
Samuel Roque. Mr. Roque, you're before the court for count 1, petty theft. Count 2 is an out-of-county felony hold. It's a no bond hold not for magistrate. And count 3 is a misdemeanor capias. I do find probable cause and the bond on.
He wishes to resolve both cases so that he can be transported to Dade.
One moment, Judge. Well, I can tell you right now, count 3 is a withhold.
Okay.
Count 1 is recovered. All right. The offered being adjudication time served, as long as he's advised. I see that the case out of date is a robbery firearm or deadly weapon, and neither myself or anyone knows how that pleading out a theft could impact a pending robbery, firearm, deadly weapon.
All right. Mr. Sanders, you need some time to talk to Mr. Roque?
I actually don't know what Mr. Linder's talking about, so can he enlighten me?
Austin, the out-of-county hold out of date is for a robbery with a firearm. And he wants to plead out a theft.
All right, I won't take a plea today. That can be determined in your division. Good luck, sir. Marcus Zelecki. Sir, you're before the court for 1 count of uttering a false instrument. I do find probable cause. What does Mr. Zelecki wish to do?
Your Honor, he can't make a monetary bond, but he tells me he doesn't want to get out of custody because he's afraid of using drugs, and he wants that you give him some kind of custody to a drug treatment program, such as Bark or House's Hope.
Well, I don't believe that I can just randomly sign an order sending him to any of these places. He needs an evaluation. So I am going to leave the bond in place for $1,000, and he can work with his attorneys in finding placement.
Will Your Honor sign a screening order for Bark?
Sure.
And SAP program while he's in custody?
Sure.
Mr. Barbaric, if you can.
I will.
And Judge, just so you know, House of Hope will allow you to sign an order straight to them.
Okay. Rod Neptune. Mr. Neptune, you're before the court for 1 count of counterfeit license plate and attaching a license plate not assigned.
No objection to the $1,000.
All right. State.
I'm not asking for modification.
All right. So the bond is $1,000. Good luck, Mr. Neptune. Joel Volley.
It's on a medical reset, Judge.
Okay. Imad Benafain. Mr. Benafain's bond's been posted. Mr. Benafain, you're before the court for 2 counts of having forged or altered credit card. I do find probable cause as to both counts, and I've been advised that your bond has been posted, sir. Good luck. Jamari Miller. Do we have Jamari Miller? Mr. Miller, you're before the court for carrying a concealed firearm, and count two is grand theft. I do find probable cause. Oh, this is. Does anyone wish to be heard as to bond?
No, Judge. I don't believe he has priors, but Mr. Linder can confirm.
Okay.
I'll run that right now. He doesn't? Okay. I'm being advised by pretrial that he has no history.
All right, so Mr. Miller, your bonds, there are two counts. Each count has $1,000 bond. Good luck, sir. All right, I believe that we are at the end of our docket. Is there anything else? No?
No.
All right.
All right. Hey, courtroom, can you guys hear me?
Yes, we can.
Any feedback?
No.
Okay, great.
Thank you.
I'm gonna mute it. Okay, you couldn't hear me, right?
No.
Okay, thanks.
Okay, thanks.
We're good.